Good afternoon, folks. Thanks for coming out this afternoon. Joe Powers, Town Administrator. And good news for everybody. I'm going to speak briefly. I really am. And I'm going to leave. I really will. And that way you can really get down to the business at hand. But first, a couple of administrative matters. First, did everyone want to make sure everyone checks in?
Well, good afternoon. With a welcome like that, how do I continue? My name is Lauren. I do deal with open meeting law issues every single day. I've been at the firm since the year 2000, which is a really long time, and have been dealing with open meeting law since then. And it's amazing because it comes up in every context. You know, whether it's the CONSCOM or Board of Health or Select Board, there's always open meeting law issues to be considering. The first thing I want to say is anything we talk about today should be hypothetical. So don't ask me a question about a real board with real people. You can make up the board, make up the people, but let's talk in hypotheticals. This is not intended to kind of call anyone out. Instead, it's meant to be forward-looking. The second thing is that in being forward-looking, we're assuming a perfect scenario, okay? There are certainly situations that can be defended as defensible, not a violation of the law. But when we're talking about the perfect world, that's what I'm telling you about today, okay? So that's the second thing. And then the third thing is that I am very curious, excuse me, what boards are represented. That would be really helpful for me. So you can, maybe people in the first row, and we can just go by row. Board.
I'm sorry, say it again.
What board?
I'm the Director of Natural Resources.
Okay.
I'm on the space and deliberation.
Okay.
Conservation and CDC.
Okay, so I shouldn't make fun of conservation and CTC.
Court Street Library Board of Trustees.
Yeah, catch it, Orion. I will shoot the recognition chair.
Okay. All right, so we have a bunch of boards. If you are a board member or you staff a board, why don't you raise your hand? Okay. Good. Well, then, you know, we have our work cut out for us. All right, so we'll start. This is a disclaimer, because I'm a lawyer. I have to have it there, but we're not going to stay on that for very long. We're here to talk about the sunshine laws, and what that means is there's really 3 sets of laws that make sure that municipal employees, including appointed board members, are kind of loyal to the town, and instead of being loyal to their own purposes. So the first one is the open meeting law, and that says all of the business of the board has to take place in open session. So it prohibits kind of backroom discussions, and it encourages all discussions about anything in someone's area of jurisdiction to take place in public. Hold on one second. Sorry. The next one is the public records law, and what that says is any records that are made or received by any appointed or elected individual representing the town, everything they make or receive in their official capacity is a public record subject to mandatory disclosure upon request. That is as ominous as it sounds in that covers a lot of records. So we'll talk a little bit about that as we go. And then the last is the conflict of interest law. And the conflict of interest law essentially says, as I was talking about loyalty, you're going to only act on things where you can have an arm's length viewpoint, not something that's right next to your home or that you have money invested in. And there are certain exemptions for appointed officials, but very few for elected officials. But this is the statute that says the town is the foremost priority rather than your individual feelings, beliefs, I guess, and concerns. And also, yes, go ahead.
The second one that you said on public records, I didn't want you to get too far away. Could you say that sentence again? And could you tell me the source and if that is written anywhere about that everything a staff member does is a public record?
Yeah, so it's chapter 66, section 10, chapter 66, section 10, and chapter 7, section 4. And what it says is any records made or received by a governmental employee are public records in their entirety, subject to mandatory disclosure upon request.
Thank you.
There's exemptions, but we're not going to spend a lot of time on that. Okay, so these are the main questions that we get all the time about the open meeting law. while, so hopefully we're going to answer those. If you have questions that I don't answer, please feel free to raise your hand and I can repeat the question for the cable. All right, so 4 major issues in the open meeting law. And the first is notice. And that's when we're going to post the meeting. We're going to make people aware of the meeting and where that meeting is going to be held. The nature of the meeting, meaning is it going to be an open session or a closed session? Then we have the conduct of meetings, which typically revolve around what's a public hearing as compared to just a regular meeting and what does that mean? And then lastly, the minutes, and that's, what kind of record are we creating of this meeting? So we're going to talk about all of those things. So this is kind of a summary just to give you a quick look, and that is nearly all meetings have to be posted at least 48 weekday hours prior to the meeting. Saturdays and Sundays do not count as weekday hours. So if you wanted to have a meeting on Monday, you have to post well in advance. You can't post on Friday, even though there's 2 days between Friday and Monday. The meeting notice has to list all of the topics that are going to be discussed, and this is a literal interpretation by the Attorney General. It used to be you could say, select board meeting, discuss open meeting law, and that was good enough. Now, it's much more specific than that, so it would be presentation by town council concerning open meeting law, possible votes taken or something like that. So you have to be very specific for a conscom. This was first decided in 2011, I believe, when the AG said fall soil permits were being issued, and they just put on the agenda fall soil permits, which seems like a reasonable thing to do. And they said, no, we need to know the address of every single applicant for a fall soil permit. So it's a very different standard than it used to be. How many of you were in the municipal government before 2011? Okay, so that's the old open meeting law, and now we have the new open meeting law. I still call it new, even though it's been around for more than a decade, but it's much more stringent and it requires much more effort on behalf of the person taking minutes and person preparing a meeting notice. Regardless of whether a meeting is properly posted, if a majority, which is a quorum of the members, speak to each other outside of a meeting about matters within their jurisdiction, that is a meeting for purposes of the open meeting law, so it's a violation of the open meeting law unless it's posted ahead of time. So let's say I went to the Snowy Owl. Let's say I go to Snowy Owl and I meet Emily there, we talk, and then she goes back to her office and we're on a board of 5. And she talks to Jen. Now that's 1, 2, 3 of us who've talked about something within our special jurisdiction. That's a violation of the open meeting law. Okay? So it can happen all at once. Like if someone sends an email, if a member of the board sends an email to all the other members, and if it's anything but scheduling, if it's great idea, I love that, violation of the open meeting law. Anytime you share your feelings, ideas, beliefs, concerns, or opinions in an email, to all of the members of your board, or a majority of them, constitutes a violation of the open meeting law. And so that's what that last one is about. Does anybody have questions about what we just talked about, kind of the basics? Yes?
So, say some members of a committee are invited to the ribbon cutting or something like that. What happens then if more than X number of members want to
So
attend?
that's a great question. The question was, what happens if all of the board members show up at a ribbon cutting? Or they show up at someone else's meeting, like a planning board meeting or something? So there are exemptions in the law for very limited purposes. One of them is for social events. So you can go to your Christmas party without worrying that the Conservation Commission is going to create a violation because they all hung out in the kitchen near the desserts. So that's one. The other is for ceremonial things, and then also for the purpose of attending another board's meeting. In each of these cases, though, what the law prohibits is deliberation. So you can all be there, but you can't, just because you're there under an exception, talk about all of the town business. Okay? And honestly, I have this story about the Conservation Commission in the kitchen. Let's see how many people. Conservation Commission in the kitchen with a clue, right? People get that that's where they came with clue. So, yes, it really is a true story. The Conservation Commission was in the kitchen at a holiday party, and they were all like huddled around the desserts. In my experience, that looked pretty bad. It turned out they were all observing brownies. I don't know what was in those brownies, but I know they were very interested in them. Okay, oh yes.
If you attend another party's meeting, like, let's say a select board meeting, and if from your committee there happens to be a quorum, not prearranged, you all just go to a lot of meetings, and if on that agenda is something that could broadly be considered to be in your committee's purview, am I allowed to speak even, usually I say, speaking on my own behalf, not representing any board or committee?
So that's exactly, the question was, what happens if you go to another board's meeting, and at that meeting, it turns out that a number of board members are also there, so that quorum is reached. And there's something on the agenda that one of the board members wants to speak to. It's okay to say, I'm speaking on my own behalf, I am a member of whatever board, but I'm not speaking on behalf of the board. You can't speak on behalf of the board unless you're authorized to speak on behalf of the board anyway, but it sends a message that's not appropriate. So I recommend people don't sit together if they go to a meeting like that. They don't ride there together, and they don't turn around when they're speaking and say, right, board members, don't you agree? Because now we're sharing feelings, ideas, beliefs, and concerns amongst a quorum outside of a posted meeting. So what that leads me to say is that if you have a board that's very chatty, and those of you who have one, you know, post the meeting as well as the meeting that they're going to. And that way, if there is turning around and saying, don't you think, and we talked about this, right, then they can do that without violating the law. They would have the same meeting notice item that the other board would have. Okay? And that the rules about not driving somewhere, not sitting next to someone, that applies as well if there's a ceremonial function, or if someone's going to go to, let's say, meet with the state reps in the city or something like that. It's not required by law. It just happens to be a way to avoid creating an appearance of the open meeting law. And that's what I was saying before about a perfect world, because it's not shocking if people wanted to ride to the city together from here, right? It makes sense. We don't have to take 3 different cars. But you have to be really cognizant of the fact that you can't talk about business when you're in the car with the majority of members. Subcommittees. So there's always a lot of confusion about subcommittees and whether they are or are not subject to the open meeting law. The answer is subcommittees are subject to the open meeting law. It's an actual easy question to answer. And what is a subcommittee? It is any 2 members who are authorized to act collectively. So what we say is, would the 2 of you please go and speak to the resources officer about whatever and bring it back to us. If we've authorized the 2 of you to do it together, you need to post a meeting. If you're authorized to do it on your own, but the woman next to you says, hey, I'll tag along, that's not a subcommittee. The example that I like to give, this isn't intended to be like a tongue twister, like a hard thing to figure out. In one of our towns, the select board appointed a quote-unquote bylaw review committee. And they appointed to that committee all the department heads and the town administrator. Was that body subject to the open meeting law? Yes, because they're all authorized to act collectively. Had they just said to the town administrator, hey, we'd like you to have the department heads take a look at the bylaws and bring up any issues that might be relevant, that is not subject to the open meeting law. No one's been authorized to act collectively, okay? So when you're assigning something to someone, much better, much safer to assign it to a single individual and let someone else tag along if that's what they choose to do. Okay? Otherwise, you're dealing with the open meeting law, and all the same rules apply, the 48 weekday hours and minutes, and being in an accessible location and all the rest. So I have it right on there. The conservative approach is to just have one person authorized to act. There's one other exception to this, which is if, for example, you guys have a charter, so if under the charter gives the town administrator authority to do X, Y, or Z on his own, then he can appoint a committee to help him, and it's not a committee for purposes of the open meeting law, because it's his committee, because he has the right to do that under state law. The actual example is for the principal, so the superintendent and principal. The superintendent is charged with hiring principals. It doesn't say the school committee hires principals, it says the superintendent does. So if the superintendent wants to put together a few people to help him or her look for, people to be on a committee, that's not a subcommittee, because he is not or she is not a committee. So if something's authorized by law for a single individual, then they can have people help them without the open meeting law applying. If you're a body, a public body, meaning more than two of you are authorized to act collectively, then anything that you do will create a subcommittee if you are going to do things together, or a committee. Okay, so this is a little bit of what I was talking about earlier. Don't drive together, don't sit together. Site visits can prove particularly difficult because, again, the exemptions that apply allow you to go to a site visit together, but they don't allow deliberation, okay? It's only exempt from the open meeting law if no deliberation occurs. Now, site visits are kind of tricky anyway. Some people post them and some don't. How about you guys? Do you post site visits? Okay, so oftentimes the site visits are on private property, and really we can't force the owner of that property to allow other people onto the property, meaning the general public. And when we post a meeting, it's also supposed to be in an accessible location. However, many boards do post it. It's more like an FYI. We're going on a site visit than saying it's an invitation to come with us to the site visit. On the site visit, if people go together, they can't deliberate over matters within their jurisdiction. And you can see how when I started, I said, in a perfect world, because it's very easy to violate the law. Take the CONSCOM as an example, because this is a real one. I guess I am picking on you. I'm sorry. I don't know. A conservation commission goes all together to a site visit, and one of the members says, "Oh my God, that pile of sticks right there is, a violation of that buffer zone, and can you believe they did that? That's horrible." And then everyone else, "Oh, that's horrible, oh my goodness." That's a deliberation versus saying, "I'd like people to note that pile of sticks." Okay? And then you can post another meeting for right afterward, a real meeting, where you go and talk about those things. So it's best to do a site visit and then come right back to a properly posted meeting and remind the members. They can take notes, they can think whatever they want in their head, but if we're going to point things out, it's only facts. Not facts and law. That's a violation of the buffer zone. But those are a pile of sticks. Right? Everyone's going to do that. Yeah. All right. And I said post a joint meeting if you're going to be going to another body's public meeting, especially if you have chatty members. And under those circumstances, it's much better to post than to not post, because you can't undo a violation without taking more action. So better to follow the rules in the first place. And the last thing is, don't email each other about matters within your jurisdiction as a board or committee. Now, this does not apply to staff, okay? This applies to members of bodies, of board reports, where, let's say there's a 5-member board. Again, Emily and I are both on this, and I emailed Emily, and that's fine. But if Emily, by accident, not thinking about it, forwards it to a third member, now that's a violation, because they know how I'm thinking, they know how Emily's thinking, and the third person makes it a quorum. Not that Emily would ever do that as a member of the board. The other thing that can happen is you can send an email to all of your board members. So-and-so came to talk to me, they raised the issue of blah. I agree, feelings, ideas, beliefs, and concerns. It's a violation of the open meeting law. something that simple. It could be something as simple as, let's say we're emailing, which we're allowed to do, about availability for a meeting, okay? And so someone says, oh, I can do it on that date. We really need to have this meeting as soon as possible because this is such an important issue. That's their feelings, ideas, beliefs, and concerns, right? Yeah, that's wild. I could see some people's eyebrows raised, but yeah, something as simple as that. So limit emailing just to scheduling purposes and try not to share any feelings. Yes, sir.
Yeah, you mentioned email in an earlier slide where if you drop an email to someone and pass it to a third, that becomes a violation of the quorum is 3.
Yes.
If you have a personal conversation with a board member about an issue, one-on-one, and then a week later you have a personal conversation with another board member, one-on-one, is that a violation?
Yes. Yep. It's a violation to have a quorum, whether it's a serial communication, so it could even be I call and leave a voice message for you, and then you send that voice message to a third person. 3 members know what I think about something. It's a violation. And that can happen when it's not even your fault. I don't know if anybody's had a situation where a board, has a concerned citizen. The concerned citizen writes to the board and raises all sorts of flaws that they believe are at issue. And one of the board members writes back and copies everyone else. Feelings, ideas, beliefs, concerns, opinions. It's a violation of the open meeting law. Okay? So you have to be really careful. It can be a serial conversation, it can be a serial telephone conversation, or it could be a serial email. Also, let's say I send that to Emily, and she's like, oh, this is important. I really think that, someone else needs to know. And she sends it to someone else who's not on the board. But then that person says, that just had Emily and Lauren's name on it. I think we should have Jen, Jen should know about this. And then someone forwards it to Jen, violation of the open meeting law, even though she didn't do anything. Even though we didn't do anything. So it's not really looking for bad actors, it's looking for the quorum of members to know the same thing. Yes, sorry.
Are you going to address social media?
Yes, I am. Totally. Let's do the agenda first, and then I think that comes right after. So, what has to be on the agenda, and this is what we talked about a little earlier in a lot of detail. It has to have the time, date, and place of the meeting. Okay? That may sound like a no-brainer, but we could say at the high school, that's a place, right? But we have to have the time and date that goes with it. Do we have to say at the high school in room 11? No, we can say at the high school. But when we get to the high school, there has to be signage that shows us where the meeting is going to be. And one of the most important things if you're having a meeting in someone else's building is that the outside door to the building cannot be locked. If the outside door to the building is locked, then people can't get in, and then it's not an open meeting. Okay? So some people that are concerned about people coming into schools will kind of station someone just at the front to hold the door open, and they stay there for the entire meeting. If they come inside at some point and the door closes behind them, it's a violation of the open meeting law. I'm trying to judge the level of concern with any of these. Okay. So the next thing about the posting or about the agenda is the meeting has to be in an accessible location. What does that mean? It means it has to meet the requirements of the ADA. Most people's homes do not meet the requirements of the ADA. Okay? However, and this is a real life example, if there's a nursing home that has a room that's open to the public, and that nursing home meets the requirements of the ADA, then that's okay to have a meeting there. So you could have a meeting in any place that meets the requirements of the ADA. Doesn't have to be in town hall or a town building. So, do you guys post online or do you post? Okay. So your official posting location is online. So whatever the mechanism is that you guys use, that's your official posting location. If your posting isn't put up, don't have your meeting. It's a violation. Okay? You're gonna have to redo it. And don't have a few members go home so there's less than a quorum. Especially with land use boards, where adjudicating people's rights, or licensing boards, adjudicating people's rights, and so doing a kind of pre-hearing or pre-meeting without the proper notice is a violation of due process. So those two individuals who stuck around to listen to people's concerns that, at the table, and they say, well, the other day at our pre-meeting, now the applicant's due process rights have been violated. So it's really important, if you don't have a quorum, you don't have a meeting, period. Okay, so on the agenda itself, you can't use acronyms. Okay, so let's say we say Harwich, Harwich High School, right? So Harwich High School, HHS. So if what it said on the agenda was 9 o'clock in the morning at HHS, that does not comply with the open meeting law, okay? Because no one knows what that, well, you do know what the acronym is, but if you're not from here, you wouldn't know. Okay, so you need an actual street address. There's also, sometimes we use short form for boards, like their School Building Rehabilitation Committee, SBRC. You have to put School Building Rehabilitation Committee on the agenda. Again, you have to assume that whoever's looking at it doesn't know anything about the town. So the time and date of posting, and I guess, Emily, you take care of that. The other thing to know about is that if you update a meeting notice, because it was something the chair didn't know about 48 hours in advance, you have to show what the new thing is on your agenda. So, and when that was posted as well. So we have the original posting with the original time, and then we have some sort of sign that there's a new provision. Maybe it's in bold, maybe it's in italics, and it says, with an asterisk, this was added to the original agenda. Right? Okay, we talked about the details. This affects new business, old business. How many of you guys still use that? Or in theory, use that? So if you have new business or old business and you know what it is, that has to go on the agenda. Okay, so let's just say it's a town administrator's report and it's about, I don't know, water issues. If we know it's going to be about water issues, then it's town administrator's report, right, water issues. Okay, if the chair has no reason to know because the town administrator hasn't given any sign or they have no reason to know, then it doesn't have to say that. But if it's like, let's say it was this, and you put down, town attorney, so it would be town attorney, presenting about open meeting law. It couldn't just be town attorney. It's all the information that someone needs when they look at it to know what's going to go on at the meeting, which is very different than the old open meeting law. Okay. Posting, we already talked about that. Just for anybody who, one second, okay. For anybody who has additional posting requirements, so zoning board, planning board, conservation commission, historic district commission, the notice that's required under those statutes is not satisfied by posting under the open meeting law. The posting under the open meeting law is one thing only, and it's just the open meeting law. If there's other notice that's required, that all has to be made available. Okay, sorry.
The monthly meetings, is it required, or are they required to be videoed and also public as well?
At this point, the question was, are monthly meetings required to be videoed? The answer is no. There's nothing in state law that mandates that. And there's nothing in state law that mandates that you hold a remote or hybrid meeting. However, until 2025, you have the ability, March of 2025, you have the ability to do that. So the difference is before you had to have at least a quorum of members of the board in the room in order to have anyone participate remotely, any of the other members. Now it could be one person in the room physically with people present and 4 members on Zoom or whatever social media, whatever media you guys use, and that's okay. But it's not required. Okay? If a board chooses to have an in-person meeting only, then they can have an in-person meeting only. And whether that's a good thing or a bad thing isn't an open meeting law issue, it's a question of policy. Do we want to be able to include people who aren't here to hear what we're saying, or do we think people who care should come here? Okay, so that's those are the.
Is there a specific statute for that?
Is there a specific statute for the hybrid meeting?
For not being required to have the meeting video?
Well, no, you kind of read it. The question was, is there a statute? And the answer is, there's nothing in the open meeting law that says that you have to, and there's nothing in the special act about remote say that you have to. Okay? All right. Emergencies. Emergencies are really like physical and, weather emergencies. It's not that you forgot you have to have a filing in tomorrow. However, I will say, I know some boards and committees that when a situation like that does come up, they say we'd rather, avoid constructive approval than worry about whether this met the requirements of the open meeting law. I'm not saying that's a good idea, but there's a risk level there that some people wind up taking under very particular circumstances. So if you have an emergency meeting, you want to comply with the law to the extent you're able. Post as soon as you know. Make sure that the meeting is held in an accessible location or on Zoom, and put as much detail into the meeting notice as possible. This is a real example. A lot of the boards of health during COVID had emergency meetings because they needed to deal with things that were, late-breaking. I've also had select boards do emergency meetings about snowstorms and about, other types of storms. Like one time, there was water coming over onto the main road in town, and they were having an election. And so they had to cancel their election, which meant we had to go to court after. But they canceled the election, the select board got together and canceled it. Okay? So those are the types of things that might create an emergency. Recording of meetings. This meeting is being recorded. Basically, under state law, any person has the right to record an open meeting if they want to, but they're supposed to tell the chair, and the chair is supposed to announce if the meeting is being recorded. So even if the meeting's being recorded on cable, it's good for the chair to just recognize that, okay, as part of their opening remarks. Okay, so now we're at the email deliberations. And email deliberations, you've already heard, are a risky activity. So never reply to all. That's a way to avoid violating the law, right? If you're only replying to one person, rather than the whole board, even if you're sharing your feelings, ideas, beliefs, and concerns, it's less likely that you'll violate the open meeting law. Especially when, and I mentioned this, when emails come in from constituents, okay? You could have a policy about who's going to respond to those emails if an email comes into the full board, and that person can respond, and essentially forward that information and make it available for the next meeting, how they respond. Excuse me. The other thing is, as I said, you're allowed to schedule using email now as a board. So the board members can email the other board members to say, we want to meet on Thursday, we want to meet on Friday, whatever it is. But the response to that has to be, I'm available, or I'm not available, or it would be better if it was on a Thursday, rather than great idea. That's sharing feelings, ideas, beliefs, and concerns, and that creates a violation. The difference, however, for staff is significant. Staff can have any feelings, ideas, beliefs, and concerns that staff would like to have, and staff can share them with the entire board without violating the open meeting law, okay? So a staff person could do a study and come up with some data and want to share that data and say, we think this is a good thing, or we think this is a bad thing. And they're allowed to email that out to people. The risk is that someone replies and says, I agree, great job. So a lot of staff members will put something on the bottom of the email, like in bright red and big text that just says, please do not reply. This is for discussion on Tuesday night. Others will BCC all the members of the board and say, as the first thing, all the board members are BCC'd on this email. Here's this information I'm passing along, okay? So staff can share how they feel. If I want to share how I feel with the members of the board, I have two options. One is I can make that available to the public at the same time as I make it available to the board. So like putting it in the packet that's posted on Fridays, okay? It doesn't mean that anyone can discuss it until they get to the board meeting on that Tuesday. The other option is to come in on Tuesday and share my feelings, okay? The law favors coming in on Tuesday to share your feelings. But I think it's often the case that there are people who are willing to do a lot of research and want to make that available to the other board members before meetings. If that's the case, it has to be made available to the public, so post it online at the same time that it's made available to everyone else on the board. We talked about emails being forwarded when you may not even know, and this is the time when I just say what all lawyers are supposed to say, at least in movies. If you don't need to put something in writing, don't put it in writing. The second you create a document, it's a public record, subject to mandatory disclosure upon request. And not only that, but you have no control over where that email goes. And these days, I always say when you're responding to something and you feel either excited or upset, when you're sitting down to write the response, don't send it then. You should give yourself an hour, walk away, and then come back, because as soon as you press send, it's out there forever, and it can be forwarded by anyone to anyone. So be comfortable reading it on a local blog if you press send on an email. And Dave Jenkins, who I don't know if you guys know, but he's a labor and employment attorney in our office, and he always says, I'm going to sleep on it before he sends an email like that. So give yourself some space and distance before you press send. Sometimes it's cathartic just to write it, like you don't actually need to send it. Okay, and then again, you saw this a bunch of times and I've said it, but I'm going to say it one more time, so hopefully you'll remember it even when you leave. Feelings, ideas, beliefs, concerns, and opinions cannot be shared amongst a quorum. So even in email, you cannot share that amongst a quorum. If you think it's a great idea that the chair said, let's talk about X, you can email back the chair only and say, Chair, great idea. But you can't copy someone else on there till it gets to a quorum. So if I want to write to the chair and I copy another board member on my email, it's a violation of the open meeting law. Okay? So the best case scenario is try not to email your whole board, or have a staff person do most of the arrangements, scheduling, etc., sharing of opinions, and that way you insulate yourself. All right, social media. This is a brand new world. Before I get there, any other email questions? Anybody? Everybody know what I'm talking about when I say don't press send? Don't reply to all? Okay. I like to think of the reply to all button as like the flashing red button that sets off nuclear missiles. So like never hit that button, because that's a danger. Try to stay away from it. Yes?
I just have one question, which is, when there's a case where there's a very active vice chair, as well as the chair, and you respond to something, does what you just said still apply only to the chair?
No, that vice chair is also a member of the board. So that's 3 members of the 5, hypothetically. It's 3 members of the 5-member board sharing feelings, ideas, beliefs, concerns, and opinions. Okay, so we move to social media. I know that I should have TikTok up there and that this is like vastly out of date, but I'm just not skilled enough with PowerPoint to get the TikTok thing and put it on there. So this is what we got. Posts on social media are subject to the open meeting law, okay? And the public records law, and since we're talking about that, which means if you post in your capacity as a town official or employee, then you are acting in an official capacity. So if one board member, let's just say, I live in Needham, we have the Needham page. Okay, so if I'm a select person and I post on there and I'm really excited that we're doing this affordable housing training, and then one of the other members of my board also posts and says, agreed, this is going to be great, the 3rd member cannot weigh in. The only thing they can say is, come to our meeting on Wednesday, because that's not sharing ideas, feelings, beliefs, and concerns. The other thing that you can't do is tag someone in your post. So if you're a member of a board and you want to post something you think is of interest to the other board members, you cannot tag them specifically in your post, because that's essentially like directing your comments to them, and if it's a quorum, it violates the open meeting law. So people ask, should I participate on social media, especially elected officials? They feel like, I was elected to represent, constituents, and I don't want it to look like I don't care. So one of the things that I've said in those circumstances is just to say, to avoid any open meeting law issues, I'm not going to post my opinion here, come to our meeting on Wednesday. Okay, so that's a way to weigh in, but not violate the law. Questions? Yes.
What if there are 3 people in a social media situation who are commenting on an area that is not in your board's purview?
Yeah, so the question was, what if you're 3 people in a social media post that's not about something within the board's purview? Then that's not a violation of the open meeting law. And so that you do have to be careful when it relates to something that you do in your official capacity. That's where you're going to want to be the most cautious. If it's not something that's in your jurisdiction, then you just want to make sure that at some point someone doesn't say, and we are the whatever board, and this is why we all feel like this. But it's okay to, just like it's okay to be in a room with everyone if it's a social gathering without violating the law. But if there's a deliberation, meaning if there's an exchange of ideas about the jurisdictional matters, then a violation is created. Okay? Anybody else? Who posts on social media as an official? Okay, so you guys are going to have a really easy time with this rule. Okay, conducting the meeting. So this is an area that we don't talk about a ton, and I think it's because every chair does things differently. And as you know, sometimes it's not easy to tell a chair what you think they should do or not do. But it is important to understand what their authority is under state law. The chair gets to determine the agenda, period. Okay? So just because you as an individual say to the chair, I'd like to address blah, blah, blah tonight, or, in 2 days, it doesn't mean that the chair has to include it. The chair could say, we're not talking about that, I'm aware of that request, I'm not putting it on the agenda, and now you can't talk about it because it was reasonably anticipated, and I said no. Now, does that give the chair a ton of authority? Yes, it does. Okay? And that authority extends to the meeting itself. The chair decides who talks and when. Does that apply to board members? Yes, it does. So if you are wanting to bring something up and you try and the chair said, we're not talking about that right now, you can't force the rest of the body to listen to you. Now, politically, there may be a different outcome if the chair acts like a taskmaster, right? That could be different. Because politically, they could be viewed as a bully or as mean or whatever it might be. But under the law, there's nothing that requires the chair to allow any person to speak. Okay. Interestingly, the difference between a public hearing and a public meeting is that at a public hearing, the public has the right to be heard. Okay? But what it doesn't say in public hearing statutes, it doesn't say for 32 minutes, each person gets 3 minutes, and no one can speak again until everyone who wanted to speak has spoken. There's nothing like that in the law. But chairs have the ability to establish that kind of rule framework. Okay? And it may be something the chair involves the committee in and says, hey, let's talk about this, how do you want to deal with it? But there's nothing in the open meeting law that says that you have to allow the public to participate at any board meeting other than at a public hearing. Okay? So any right to speak comes from a different statute, not this one. Yes?
In terms of putting the agendas together, does the chair have any authority to negate what the department head might want, what the department head may want to do?
The question was, can the chair kind of negate what the department head wants to do? It's the chair's agenda in the most basic of terms. Again, I think there can be significant political consequences for kind of wielding that power as a tyrant or a kind of all-powerful person. But I have seen it, and there's really no remedy because they're the chair. Could they reorganize? Could the other members reorganize? Probably they could figure out a way to do that, unless you're appointed for a term of years as chair. okay? And obviously, that's not ideal, right? No one wants to be on a board like that or to have to try and reorganize a board like that. Yes.
You said that a public meeting, no individual has the right to speak.
Under the open meeting law, no one has the right to speak.
Does that exclude public comment section?
So the question is, this idea of a public hearing and a regular meeting, and being able to say at a public meeting that the chair decides who speaks. The question is, does that apply to public comment? Now, I don't think you guys have something in your charter about that. So there is no requirement under state law that you have a public comment period. Okay? And it's actually very important that if you do have a public comment period, that you are exceptionally cautious about how you do it. And we're going to talk about that next. Sir?
Just to get back to conservation, then. Conservation meetings typically consist mostly of what we refer to as public hearings for different permit applications. So when you mention in a public hearing, then public comment is required, and the chair cannot shut that down.
So the question is, like conservation, they act on a lot of applications, and there's a law that says that the Conservation Commission has to have a public hearing. If there's not a law that says the Conservation Commission has to have a public hearing, but that's just kind of the normal way of doing things, then it's not a violation of the open meeting law to not let people speak. Again, the two laws are separate. So the conservation laws about who gets to speak at meetings, what the applicant rights are, that's separate from the open meeting law. So if a right is provided by another statute, the open meeting law doesn't override it.
So I didn't hear an answer to my question, which is the chair in a conservation meeting required always to allow public comment?
No, a chair is not required always to allow public comment. It's just if there's a statute that gives the public the right to be heard, and that's it. Not in general for a conservation commission, it depends. It depends what statutory format you're working in or what applications are in front of you. And this is why it's really important to recognize that compliance with the open meeting law is just one part of your obligations as a board member. If there is a right to be heard at a public hearing, which means that the statute allows, the statute provides for a quote-unquote public hearing, then the chair still gets to decide how long that's going to go for, who's going to be able to speak in for how long. There's nothing in the law that says it has to be, as I said, for 32 minutes at the beginning, or 32 minutes at the end, or 32 minutes in the middle of the meeting. That running the meeting remains within the discretion of the chair. Issue. Is anyone aware of the recent case Barron v. the Town of Southbridge? Okay. In that case, essentially, a disgruntled resident appeared at a meeting to speak after a number of other people had spoken and said good things, and this resident wanted to complain, basically. She said that the select board members were criminals. She was holding up signs that said criminal and some other stuff on it. And as you can imagine, the chair was annoyed about this. She was loud. She was like really vocal. And normally, people, even when they're upset, are asked at meetings to kind of be polite, be respectful of who's around, don't use names if you can avoid it, say the previous speaker like at town meeting. So she didn't do any of that stuff. And he told her to stop talking, and she didn't. And so he called for a recess. And when he called for the recess, you can see him off to the side in the video screaming at her, "Get out of here," yelling at her to leave. And she sued the town, and she won. And what the court said is, nobody has an obligation to be polite. They can be rude, they can say things that the government doesn't like, and that is their right. If you're allowing public comment on anything, then they can come in and talk about anything, and they can be positive or negative. So whether to allow public comment is a policy decision in most instances, anywhere where it's not a public hearing. And the question of how to manage that is something that you need to think about before you have the public comment period. Because This new case basically says that if someone comes up and they're rude and obnoxious, but you're allowing people to speak for 3 minutes, they have 3 minutes to be rude and obnoxious. They could call you a criminal, and you have to let them keep speaking. And that's a lot. It's a lot to handle. Yes, in the back.
Are you allowed to limit the time? Can you say we have 3 minutes, you have 3 minutes?
Yeah, the question is, are you allowed to limit the time then that people can speak? And the answer is absolutely. So the board or the chair on the chair's own initiative could decide that they're going to have, and this is real, I'm going to tell you real stories, 15 minutes of public comment with 3 minutes each for 5 people. If more than 5 people want to talk, everybody gets 2 minutes. But at that 15-minute mark, regardless of who's talking and whether we like what they're saying or not, we're done. Now, the hard thing for the chair is to understand that if they allow somebody who's being polite to keep talking past their time limit, then not allowing the obnoxious person to do that could be viewed as a violation of their First Amendment rights. So having a policy means you stick to it. If you don't have a policy, you just say public comment, then you really have to make sure that you're treating everybody the same. So it's useful to have a time limit. It's useful to have like a total amount of time limit for public comment. It's useful for the board to consider whether they want that at the beginning of the meeting or the end of the meeting. And there's pros and cons to both. It's useful for the board to consider whether the public comment is about things on the agenda. So just what we're doing tonight is what you can talk about. Or about things off the agenda. So select board, you can talk about anything that you want to, we're here for you. Okay? Yes? Lots of hands, just one second, go ahead.
I assume there are limits to this. Threatening or discriminatory speech, at some point, the chair must have the right to tell people they cannot continue to talk.
So the question is, there has to be some sort of a limit, and there is a limit. And I'll tell you more about it in 1 second. But essentially, if there's a real threat of violence, that's something that can be stopped. But if I just say, I hate you, and I'm going to follow you around and yell at you, that might not be able to be stopped. We don't have a case that says so yet. But someone could test those boundaries. Now, they also talk about how there could be circumstances, this is the court case, there could be circumstances in which a chair could kind of rein people in, and they give an example of if they say something like hate speech. But at this meeting, the woman, and this is why the chair got so upset when she was standing up there, she called him Hitler. Okay, and he was really upset, as would anyone. But the court says that's not hate speech. So we're talking about standards that are really hard to meet. Yes, sir.
To follow up on that, if a person is speaking within the proper time frame and so forth and addressing the issue at hand, but a member of the board feels threatened, the person doesn't have a weapon showing or whatever, but because of the language, maybe threats are made, does the chairman have the right to stop the person from speaking, or even one step further, if it gets out of hand, quote unquote, they go past their time and they continue to use language that somebody on the board feels threatened. I may not, but he might. Do they have the right to, at that point, either threaten the speaker with law enforcement involvement, or actually physically call law enforcement to attend, and then it becomes a criminal issue versus a...
This question is as complicated as the law school bar exam, okay?
Sorry.
No, that's okay. There's like, each piece of this is unpacked in a separate way. I'll tell you a story, and this is real, again. A man is attending a meeting by Zoom. He wants a chance to speak. Everyone has 3 minutes. He spends half the time arguing with the chair about what he's going to talk about, even though the chair didn't make a big deal out of it. Then he has 1.5 minutes left, and at the end of the 3 minutes, the chair says, that's it, time's up. And he's like, I didn't get my 3 minutes, and this is, outrageous. But he's not allowed to speak again. And about halfway through the meeting, he shows up with his wife at the meeting. And when he gets in, he stands up and he starts just talking about what it was that he wanted to talk about. So the chair says, I'm sorry, this isn't a time for public comment. You're going to need to sit down and stop talking. He says, I'll do what I want, blah, blah, blah. The open meeting law says the chair can refuse people to talk. And if they don't stop talking, they can tell them to sit down, and if they don't sit down or they don't stop talking, they can have them removed by a constable, okay? Typically, constables aren't running around available at meetings, but the police department is. And so in this instance, the police were called, and it turned into a huge, huge thing, and this man who was doing the speaking was arrested. Now, do you think that's good for the town? No, it's not. Because there's going to be a whole debate now about whether the chair acted outside of his authority when he did that. And the scary thing is, if it turns into a civil rights issue, civil rights municipal employees cannot be reimbursed for the costs of defense or the costs of a finding by the court, because it's a criminal issue. So it's important to understand that even though something might feel distasteful, it's not enough to make that person stop talking. And that's why you want to have rules like you can't talk over one another. If someone has the floor, no one else will speak until another person is recognized. People won't yell out from their seats. And all sorts of content-neutral restrictions on that kind of speech. It's not about what people are saying, it's about what they're doing. And as long as you keep it to what they're doing, then you're okay. If the message doesn't matter, so anyone can get up and say anything they want, they have 2 minutes to do it, go. We listen for 2 minutes, and you rant and rave about this or that, you get 2 minutes, and then at the end of your 2 minutes, you're done. And the chair can enforce that.
You need to have a policy which applies to all this, written policy.
So the question was, do you need a written policy? My thinking is that it's good to have one, because that minimizes the ability for someone to say that they are being discriminated against. But there's no law that says that you have to have a policy. However, the chair has to be careful not to favor people who are going to agree with them. They have to hear from the people in the room on an equal basis. I saw some other hands. Ma'am.
Under the public comment section, in addition to time limits, is it legitimate to further qualify the content? For instance, to say public comment, comments must be passed into the chair in writing in advance.
So no one's ever asked me that before, and no one has ever asked me whether written comments have to be approved in advance. But I would say that that sounds more like a prior restraint on speech, which would be a constitutional violation of the First Amendment. Yes, sir.
So following up on the example that you gave as a first answer to my question, I think you said, if I understood correctly, that specification you cited did end up in a criminal situation. What was the crime? Do you know what the crime was? Was it a threatening?
I know what the crime was. The crime was that he didn't stop talking when he was told to, and he created a public disturbance. So basically, it wasn't an open meeting law kind of thing anymore. As soon as the police got there, it changed. So the question that, or the issue I would ask you to think about is that the way to handle these types of things? And we actually at the firm sat down together, all the attorneys, to talk about what could he have done, what could the chair have done differently, right? He could have said, yeah, that minute and a half that we spent arguing about what you were gonna say, like that doesn't count towards your 3 minutes. If he'd done that, then the next time someone wanted to argue about whether they could say or not say something, then he'd have to allow that too. He could have, instead, when that gentleman said, I didn't get to read my piece, he could have said, I'd be happy to put it into the record. If you have it written down, feel free to give it to me. But he didn't say that. And when the gentleman arrived and he was upset, the chair could have taken a recess before that person even started talking. The second he saw him come in, could have taken a recess to just figure out, like, how am I going to deal with this? Because this is an important thing that's going to happen here. We know he's going to claim a civil rights violation if we don't let him speak. So there were several places where the chair could have reacted differently. And, you know, just so that you don't think we were just picking on you guys, we were also saying, what if council was sitting there? You know, what do you do as town council if something like that's happening? You can't tell the chair not to do something. You can suggest it, you can give ideas, but you can't say no, you're not the police. So the takeaway is de-escalation is the best policy, okay? Even if, you know, you have to enforce the rules the same way, so 3 minutes, 3 minutes, 3 minutes. But if that 3 minutes is altered for some reason, you know, it might be worthwhile to say, okay, this person didn't get to speak their mind for 3 minutes. Now, you don't want to encourage that, but that would have made the whole thing go away. He wouldn't have come down to the meeting itself. He wouldn't have gotten arrested. It wouldn't have been an ugly, ugly situation. So how can you de-escalate? When the gentleman came in, he could have said, you know, again, I know that you have your, because he was holding his whole speech, I see that you have your speech. I'm happy to put it into the minutes. Anybody who wants to read it can read it. Nothing happened. And someone else actually called the police, not the chair, which is interesting because the chair had to deal with that anyway. And even the police didn't want to come in and tell the chair what to do. So basically, the police were there until he was unruly, and when he was unruly, they arrested him. Yes?
What about when the chair tries to deflect almost by saying, we only want to hear new information? We don't want to hear something we've already heard before.
So the question was, what if the chair wants to deflect and say, only new information, we've already heard all of this before? That's why it's good to have a policy, because then you have a certain time limit on who can speak and when, and so it's over before you get to the point where the chair has to choose. If the chair has to make a discretionary determination and they stop the discussion and it's about negative things, it's going to look like a First Amendment violation. So it is better to have a policy, X amount of minutes, speak for X amount of time, and that's that, than to go through all of these gyrations. Some communities will have, one second, I see. Some communities boards will do a listening session, for example. So let's say we know that topic X is a huge issue. There's no requirement for a public hearing, but our meeting was jam-packed with people who wanted to speak and not everyone got to speak. Well, they can post a listening session where the job of the select board or whoever the multiple member body is just to sit there and listen so that people get to say their part. And there's nothing that prohibits that. Again, I wouldn't say it should be a free-for-all. There should be rules, 3 minutes a person. You know, maybe the meeting will end in an hour and a half, regardless of who gets to speak. 3 minutes a person, that's what we're going to do. So having that decision-making about non-substantive content is a very important tool. Okay, so as long as you're not saying we're not going to let so-and-so talk because we don't like what they're saying, or we're sick of hearing what they're saying, then you can still cut the person off. If what they say is, we've been going at this for an hour, I'm going to let you speak, and then we're going to move on. That's okay, because they're not cutting off the bad behavior. They're just saying, we've been doing this forever. We got to finish up. So again, it's a tightrope kind of thing. Better to have a policy. So additionally, and this is the hardest part, we feel very strongly that if the board, oh, I'm sorry, you had a question.
Sorry, I just wanted to ask, so if you have a public comment posted for a committee, but then, you know, other items on the agenda, do they have to address items on the agenda in public comment? Or can it happen during the meeting as well? Is that the choice of the chair?
It's the choice. The question is, does input from the public have to occur during public comment if you have public comment? And the answer is no. It's completely up to the chair to allow comment or discussion with members of the public during a meeting. Again, though, there's going to set a precedent And so if they set that precedent, they have to make sure that they don't turn off that spigot at a different time because they don't like what someone's saying. Okay? And actually, one of our towns, they have a policy, and they have a policy that if you're there to speak, you can speak on anything that you want to, except if there's a public hearing on the agenda, you have to speak during the public hearing if that's what you're going to speak about, because of due process rights of the applicants. So in that situation, it's the due process rights of the applicants will be negatively impacted if we have a whole discussion about this outside of the public hearing. Okay.
Can you put open meeting down the bottom of the agenda, open session, and just let people speak?
Absolutely. You can put it at the end, you can put it at the beginning, you can put it in the middle. If your charter doesn't require it at a specific time or at all, then it's up to the public body to decide. And whether to do it is another whole thing, because if you can see here, the number one thing that we say to do is avoid debate. So during that public comment period, people who say you're doing a great job, we're so happy with you, or you're doing a terrible job, we're so upset with you. And either way, the chair says, thank you for your input, let's move on. Now, especially if you're being called a criminal, I imagine that you're going to want to say more. But it is better not to say anything, okay? Because the second that you start with that, tensions are going to rise, there's going to be people going back and forth, the chair's going to lose control of the conversation, and now you're in a spot, okay? The other thing is, the committee hasn't had a chance to think about that thing. If someone stands up at a public meeting during public speak and says X, Y, or Z, it doesn't mean that all the members know what X, Y, and Z is. So it's premature, really, to talk about that thing. Now, there may be exceptions to that, but as a general rule, avoiding debate, just using, and I've actually practiced this with people, thank you for your input, we appreciate you being here tonight, thank you for speaking, nothing substantive. And if people get upset, oh, we want an answer, the chair can say, we haven't had an opportunity to think about that yet. We're happy to put it on a future agenda, or make an appointment and come on in next week to be on the agenda. So there's different ways to deal with it, but the debate is dangerous, okay? Unresolved. We all kind of are conditioned to want to resolve problems, right? Someone comes in and they say, I don't know, do you guys have garbage pickup? Okay, let's pretend we have garbage pickup and someone comes in and says that they haven't been picking up our garbage. And, I want this dealt with, and I want it dealt with now. Well, a select board chair, for example, might say, oh, we'll deal with that, we'll talk to, but it's better to leave it unresolved because we don't even know if that's true, right? We haven't even talked to the caller to find out if that's true. So saying, we'll look into that, or the town administrator will look into that, is a fine answer. And sometimes that's the best answer that there is. Okay. See, that was the most fun, right? I'm obviously being sarcastic. This is a really hard area of law. And people will say, oh, you've been doing open meeting law for so long, it must be boring. Like, it's never boring. Every single circumstance is different. And when something like this happens, the entire kind of framework that we used to think about open meetings has changed. So, staying up to date is hard to do, and, luckily that's part of my job, but it's kind of unlikely that as part of people's regular work that they're going to understand the implications of something like this. So we're trying to get the word out, and we do have a e-update on the page, on the table over there about this to give you a little more information. Okay, so if a matter comes up that's not reasonably anticipated by the chair, it can be acted on, okay? There's nothing that says that it can't be. So let's say someone raises, and this is a real story, we have to approve this appointee to this bike committee, or we're gonna lose a federal grant, so I'm asking if we could make this appointment tonight. They can go ahead and make that appointment, because the chair had no reason to anticipate, like they thought it was gonna happen in October, and here we are in July. So they can deal with that. But they don't have to. And what the AG says, it's not the law, but the AG says it's better if you can put something like that off, to put it off to appear on a properly posted meeting notice. But that is not the law, so if there is a need to act or a perceived need to act on something new, it is acceptable to do that, as long as the chair didn't reasonably anticipate it. Okay, minutes. So minutes essentially have to be substantive. It used to be you could do like a little summary. Lauren discussed the open meeting law. Instead, if you were going to do this under the new open meeting law, it would be Lauren presented this particular slide, there were questions that were asked, she answered blank. It doesn't have to be a transcript, but it's supposed to allow someone who's not there to actually know what happened at the meeting. These are the things. Okay. Minutes now, there's a regulation that says they have to be approved within 3 meetings, or within 3 meetings or 30 days, whichever is later. So for those of you on board that meet quarterly, that's fine, you don't have to meet earlier to approve minutes. If you meet every week though, you're gonna wind up having to make sure that your minutes are up to date, because you only have 3 weeks, and if you go beyond that, then, or 30 days, then you're gonna wind up with a violation. And the AG is really strict about these things. The letter they write says you have violated the law, and in my experience, that gets a lot more press than if it just said, you know, please be careful next time to do your minutes on time.
Do the minutes need to contain a narrative of who said what?
Yes, they do. The minutes have to contain a narrative of who said what. Not every word they said, but for example, concerns were raised about threatening language would be kind of the summary of that part of the conversation we had.
The person who said that, in other words, the name people.
Yeah.
Johnny Jones on the committee says something that's a narrative, you have to put his name in the minutes.
Yeah, it's supposed to be very specific. So I actually can tell you that a number of boards that do meet every week or every other week have outsourced their minutes now. And basically what they do is they send a video to a transcript service. The transcript service, you know, prepares a transcript. They adopt that as the minutes. And I'm not saying that's the only way to do it, but it is one way. The other way to do it is, if you know we're going to have a conversation about things and you're the person responsible for taking minutes, is to set it up ahead of time, you know, if you're typing it, so that you know you have issue number 1, and you know one board member is always angry about that. So you can pre-fill in the things, you know, so-and-so indicated his great displeasure with blank, right? Because we know he's going to say it. It doesn't mean it stays in if he doesn't say it, but it's a way to kind of prepare. Or if you're going to be giving a presentation, if you're the person putting the agenda together, then you know what you're going to talk about, so you can put your part in even before the meeting so that you're kind of have a head start. Executive session minutes. Oh, sorry. Yes.
Question on the votes. I know you need to have the votes, how many yes and no. Must you put down who voted which way?
So the question is, do you have to record who voted which way in minutes? So in open session meetings that are not remote, there's no requirement that the individuals who voted one way or the other be recorded in general. If the vote is to go into executive session, then yes, who votes which way has to be recorded, even if it's unanimous, with the idea that, you know, 10 years from now, we might not even remember who was there or who was part of that committee. If you have people on remote, then you have to take all of your votes by a roll call vote, and that's how it has to be recorded. I don't think I'm going to spend too much time on executive session minutes, so you guys can read that. But the biggest takeaway is, oh, sure.
So for executive session minutes, we always get confused. Do you have to vote to approve executive session minutes in executive session, even if it's the only thing that's going to be in executive session?
So the question is, do you have to meet an executive session to approve minutes from an executive session? If you want those minutes to remain withheld, to remain confidential, then yes, you have to post a meeting. You post the meeting with the first item being open meeting, or convene meeting, something like that. The second issue would be the executive session, and you can go in under two different exemptions to the law. You can go in under exemption 7, which is essentially to comply with other laws, or you can go in under the original reason given. So if it was collective bargaining, you could go in for collective bargaining to approve the minutes.
We always have land negotiations, so.
It should be executive. Otherwise, you take the risk that someone says, hey, you approved those in open session, like they became public, you used them at a meeting, you talked about them, they were there. So,
Then where do you post executive session minutes once it's so clear?
so I don't know what you guys do with your minutes. Do you post them online? Yep, so they would get posted like any other minutes.
If they're released. So you would approve and release. So as Lauren was just saying, you could approve minutes and keep them private.
Yeah.
But if you decide that the reason that they were private no longer applies and you're ready to release them to the public, we would post those.
I thought there was a longer timeline that you can hold executive session minutes for an extended period of time.
So-
Release right away.
The question about the public records status of executive session minutes. It's, as Emily just explained, executive session minutes can be withheld from disclosure as long as the purpose for withholding them hasn't expired. So, for example, if you went into negotiations with non-union personnel for a contract for X, Y, or Z thing, and the board comes out and it votes to approve the contract, then those minutes are no longer secret because we know exactly what resulted. On the other hand, if they don't come out and approve a contract and they go back in 3 more times to negotiate or to strategize, then those minutes do not have to be disclosed. There are good reasons for disclosing executive session minutes, and there are good reasons not to, and the decision should be made on a case-by-case basis. What you're looking to protect particularly is individual rights and or the municipality's bargaining position, whether it's in litigation or collective bargaining. Yes?
Once you've decided that the issue is passed and you have the properly voted executive minutes, do you just post them? Do you have to announce you're posting them, the issue was passed? And one more, I definitely could be wrong because my memory's getting faint, but I've really never noticed any executive minute postings, just for example, from the select board on our website.
So I will say, there are different ways of handling things. There's no requirement that minutes be posted on the website. So, and I don't know what the select board's policy is. I will say it's good to have a policy where you look at executive session minutes, maybe quarterly, and say, has the purpose for these executive session minutes expired? For example, maybe it was litigation strategy, but there's no appeal available anymore, and they can be released. So looking at it on a regular basis is a good thing.
So I guess I didn't follow that. So you don't have to announce then? I mean, how do you actually get rid of them?
So the question of how to release executive session minutes. Essentially, you're going to have approved executive session minutes of the following dates. So it could be approve and release executive session minutes for the following dates. And that you could do in open session if you're comfortable disclosing them.
So I mean ones that are already approved. You would say like release executive sessions in the following?
Yes, if they've already been approved for release, you would have that on the agenda. It would typically say release the following executive session minutes.
And through you to Emily, do we have a section on the website for executive minutes, or I just haven't noticed it?
Thank you. I think from my experience, we don't have a lot of boards that meet in executive session, nor do they have to, because they're not meeting in executive session, prepare minutes that they submit to us. I've probably only seen 2 or 3 sets of executive session minutes come across my desk that have been approved since I've started that were not subject to release. So oftentimes the reason for going into executive session still stands, and so they have not been released to the public, and so they're not posted publicly. But if they are released to the public, we would put them in the minutes section for that board.
But I'm honestly thinking back 15 years, and, the select board has practically every week executive session.
So I hate to cut you off, but I'm going to, because essentially this is kind of a real thing. It's a real question, right? We're talking about actual behaviors, so that's something that we can talk about after, that the clerk can follow up on. Other questions? Yes.
So one related question I didn't hear an answer to was, is there a requirement for a board who enters into executive session, approves minutes, is it a requirement that those minutes at some point get released, or that the board continue to make affirmative decisions about whether or not they're going to be released?
So-
There was an executive session 2 years ago, minutes were written, they were approved by the board, but nothing further was done, but the issue was no longer a reason to keep them private. Is there a requirement to deal with that?
So, under the open meeting law, if a request was made for the minutes, they'd have to be reviewed and disclosed if the reason was expired. That's why I said it's a good idea to review them on a quarterly basis, and to keep up and keep fresh with what should be released. But there are some things that could stay exempt for a super long time, particularly where there's a long litigation, or where there's a very an extended collective bargaining period. Anybody else? Okay. I have no idea how many slides we've gone through, and I have no idea how much time we have. But we're going to go quick now. Okay. Enforcement. Anybody can file, any resident can file an open meeting, well, actually, not just a resident. Any voter can file now I said voter, I think it's any person. Any person can file an open meeting law complaint. Sorry, I'm glad that's on the record forever and ever. And they have to do so within 30 days of the day of the violation, or within 30 days of the day they should have known about the violation. So this is not a gotcha statute. It's not supposed to be. It's supposed to be related in time to what's going on, instead of being, backward-looking 3 years. Once the public body gets a copy of that, it has to be on the form that the AG has prepared. I kid you not, it has to be on that form for it to be valid. And the board has 14 business days from the day of receipt to act on that. And by act on it, it means acknowledge receipt and either decide how they want to respond or authorize someone to respond on their behalf. Okay, so 14 business days is almost 3 weeks. And then after 30 days, the complainant can go to the Attorney General and ask for enforcement by the Attorney General. It can't go before then, but they can go after the 30 days. We already talked about Barron v. Kalenda. There's a NEDA case that is similar to that. It has to do with the school committee putting on its agenda the words town meeting warrant review, which the court said is not sufficient. It had to be Articles 7, 11, 21, and 23. And if you're shaking your head, I completely agree. You never know, really, what questions are going to come up about a warrant, even if something doesn't appear to be related to the school committee, for example. They might still want to talk about something. But that's what the court says. And let's see. I think that's enough for... Okay, so how long is this going to last? And we did talk about this a little bit, until March 31, 2025. You can hold hybrid and remote meetings. You don't need special permission to do so. But must these meetings be held remotely? No, that's an option. If you are going to provide, if you are going to hold your meeting remotely, you need to provide adequate alternative access, and that means essentially that people in real time can hear what's going on. So Zoom is a good example of adequate alternative access. Let's see. These are kind of just, all votes have to be taken by roll call, which we talked about. Oh, the remote members have to identify themselves. So either the chair says, Ms. Smith, and Ms. Smith says here, or the chair says, let's go around and introduce ourselves. Okay? And you're not going to find a case on this, but cameras should be on if you have a camera. Now, there's no law, there's no finding that has that as a mandatory outcome, but it is kind of consistent with the open meeting law to think that if someone's going to be participating in a public discussion, that we should be able to see them. Now, maybe not the members of the public, but for the board members. And sometimes, especially when you need to recuse yourself because of a conflict, that's a good time to say, I'm gonna turn my camera off and, act as a member of the public, or even be asked to be removed from the panel to be a member of the public, so you're not on screen. Yes?
Remote participants, considered part of the quorum or not?
Remote participants are part of the quorum. That's why the entire board can meet remotely until March 31, 2025. And if we're lucky, sometime around March 29th, 2025, they'll extend this law even further, but we won't know till then. So we'll again scramble to come up with ideas on how to deal with things while there's a break in that. But this is something the legislature is talking about all the time. So as soon as the elections pass, then we'll start hearing stuff. Okay. And then we talked about hybrid meetings. In-person meetings, so meetings can be held in person. If they're in person and there's no remote access being provided to members, it can just be an in-person meeting, and that's fine. The other thing is, if the meeting is in person and the board feels comfortable with the board being in person, but doesn't want a ton of people sitting out there in the room with them, they can decide that they will meet in person and the rest of the meeting will be remote. So the board has discretion to do that. Yes?
Says there, you can hold the meetings in places where masks are required. Can the chair autonomously require this?
That's not an open meeting law question. So it's completely unrelated. There's nothing in the open meeting law that says that a chair can require masks. Okay? We reset. I'm happy to answer any remaining questions. Yes?
Just a quick question. A lot of times people choose not to vote on minutes because they weren't in attendance at the meeting, whether it's regular or executive session. Is that a thing? Can they not?
The question is, a lot of times board members say, I don't want to vote on the minutes because it wasn't at the meeting, whether it's in executive or open session. There's nothing that prohibits a member from approving minutes for meetings they weren't at. It's really a ministerial function because actually the minutes of the meeting are even before they're approved, are the minutes of the meeting until such time as approved minutes exist. So they're really just kind of putting a rubber stamp on the minutes. Sometimes though people don't like to do that and that can lead to other issues, but I think it's something if you want to talk about, we can talk about more. Yes, in the back.
Are these slides going to be made available for us?
Yes, the slides are made available for you. Yes.
You talk about expressing or deliberating, expressing opinions, thoughts, or ideas. But you can talk about football games, you can talk about grocery shopping, anything else. You just cannot talk about things that are relevant to your board.
Correct. So the question is, even though you're not supposed to share feelings, ideas, beliefs, and concerns about matters within your jurisdiction, is it okay to share other things? Yes. I mean, we have situations where husband and wife are both on a single board, and we expect that they are talking to each other at other times, but they're not supposed to talk about their board business.
Are there any, we talked a lot about policies today. Are there generic policies available that can be available to us to use as guidelines and put our own policies together from the?
I can send you the policy that we developed for another town, and you can certainly, customize it the way that it feels appropriate. Yep. Anybody else? Well, thank you all for being good sports. Thank you for listening. I appreciate your time.